Okay, so it looks like lots of you are in already. So welcome to our latest employment law webinar. I'm Angie Crush. I'm a partner here in the employment department at Thomas Mansfield. And today I'm joined by my colleagues, Alison Crabtree and Jenna Ide.
Hi.
Thomas Mansfield, for any of you that don't know, we specialise in 4 areas: employment, family, litigation and private client. And here in the employment department, we work with HR managers and HR teams, as well as business owners who don't have an HR function. Now, today we're looking at pregnancy and maternity rights and discrimination. And of course, there are other types of leave, such as shared parental leave, etc. But today we're focusing specifically on maternity leave. Now, we'll split it into sort of 2 broad sections: the life cycle of a pregnant employee with the rights and responsibilities that come along the way. And then we'll look at the tricky issues that can crop up along that journey as well. Please feel free to ask questions that you have along the way. Put them in the chat box that's on your screen, and we will try to answer them. If we can't get through all of them, then we'll respond separately afterwards. And we've also said it'd be great if you could put in the chat box any subjects for future webinars you might like to see us cover. Now, I said we're concentrating on maternity leave today, but instead of doing a poll at the start of today, what I'd like you to do is to just put in the chat box your experience, whether your employees are still in the main using maternity leave, or whether you're finding that they're actually using a mix of maternity leave and shared parental leave, for example, whether that shared parental leave is becoming used increasingly. Certainly that's what I feel we're seeing in practice. But it would be great if you could just either write the word maternity or mix in the chat box, just so we can get a flavour of what's happening for our viewers out there for the potential how changes that might be happening in that area. So that would be interesting to do that, and then everyone can see what everyone's experiences are. So yeah, some people are still saying maternity, and then quite a few are saying that they've got a mix of both being used, which I think is really encouraging, because if there is a mix, it shows that that men are increasingly taking some of this leave as well. So that's really interesting. Thanks for popping that in there. So Jenna, let's start at the early stages. Now, probably one of the first things is going to be antenatal appointments. So what are the rights regarding antenatal appointments?
Yeah, so there are broadly 2 rights regarding antenatal appointments. Firstly, the pregnant employee is entitled to take time off for the purposes of antenatal care. And secondly, there's the right to take time off to accompany the pregnant woman. And that applies to certain other employees, for example, the child's father. One of the differences between these 2 rights is that pregnant women have the right to paid time off, whereas the other right to accompany is to unpaid time off. These rights I've just mentioned apply not just to employees, but also to agency workers, provided that they meet certain criteria. But basic workers do not have these rights.
And what would classify as an antenatal appointment?
Well, it's pretty clear that the usual antenatal appointments and medical examinations would be covered. Government guidance states that the right can also include relaxation classes and parent craft classes, provided that those are recommended by a registered medical practitioner, midwife or health visitor. In the case of Bateman and flexible lamps, a tribunal held that the classes in question were actually educational rather than medical, and so didn't fall within the statutory right. So there is still a lack of clarity there, given that there isn't actually a statutory definition of antenatal care.
And can an employer refuse time off for antenatal appointments, whether in the case of a pregnant woman or someone looking to accompany her?
So in both of those cases, the answer is yes, but only where it's reasonable to do so. Unfortunately, there isn't any sort of legal guidance as to when it would be reasonable to refuse the requests. And as is often the case, there is little or no case law to assist. It may be that if a pregnant employee gives short notice for a non-urgent appointment where cover can't be arranged by the employer, it may be reasonable to refuse time off there as an example. I should add that the right to accompany is limited to only 2 appointments lasting no more than 6.5 hours each. So any requests to accompany any additional appointments can legally be declined by the employer. But I would suggest that the employer should explore alternative options with the employee, such as the use of annual leave or allowing the employee to make up the time, for example. If employers do ask for evidence of the appointments or entitlement, as we'll come on to shortly, the entitlement to time off would fall away until the relevant evidence has been produced.
Okay, and who is entitled to take time off to accompany a pregnant woman to antenatal appointments?
So the right applies to either an employee or an agency worker who has a qualifying relationship with a pregnant woman or the expected child. So broadly speaking, this will most commonly cover the pregnant woman's spouse or civil partner, the baby's other parent, or a person who lives with the pregnant woman in what's called an enduring family relationship, basically their cohabiting partner.
Yeah, and sometimes employers can be a bit nervous about asking for sort of proof of these appointments or evidence. Are they entitled to ask for evidence of antenatal appointments?
Yes, they are. And that applies to both rights that we've been discussing, apart from in the case of the pregnant employee's first appointment, where evidence isn't required. So in the case of a pregnant employee looking for the time off to attend an antenatal appointment, the evidence required, if the employer requests it, the employer doesn't have to, would be a certificate stating that the employee is pregnant and an appointment card showing that an appointment's been made. Of course, a MAP B1 form isn't required at this stage. It's unlikely to have been produced anyway. It's not until 20 weeks that that's produced. And in the case of the right to accompany a pregnant woman, the employer can, if they wish, ask the employee for a signed declaration, basically confirming that they're eligible for the time off.
Yeah, and it's one of those things, it's always good to have them in your policies that these are what's required, and then there's no awkwardness around asking for them. But what are the potential employment tribunal claims that someone could make regarding antenatal appointments?
So claims could be brought for an unreasonable refusal of the time off in relation to both antenatal care and the right to accompany. In addition, in the case of the pregnant woman taking the time off for antenatal care, if she's denied her normal rate of pay, because of course that should be paid, then that can give rise to a claim as well. The compensation for that would be twice the amount that the employee would have received when taking the time off. But a refusal to allow a pregnant employee the time off for antenatal appointments could also give rise to an unlawful pregnancy and maternity discrimination claim. This actually happened in the Employment Tribunal case of Ms. Matsuzate and Kozinka Taste of Europe Limited from earlier this year. It's quite a recent case. And in this case, there was a sales assistant who worked in the shop. She was pregnant and she needed to attend antenatal appointments, and her shifts were deliberately altered so that they wouldn't end up coinciding with the antenatal appointments, and that was actually held to be unlawful pregnancy and maternity discrimination. I'll actually be coming back to this case briefly later on as well.
Thanks, Jenna. So moving on to the next likely area employers will be thinking about, health and safety protection. Alison, do employers have any special duties around health and safety when an employee is pregnant?
Well, all employers are under a duty to protect the health and safety of all of their employees and to assess the risk the workplace could pose. And an employer who employs any women of childbearing age to do work that could involve a risk to a pregnant woman, to a new mother, or to a baby, such as from chemicals or from physical work, must assess these risks specifically, even when they don't know that any of their staff actually are pregnant. And then once an employer has been notified in writing of a pregnancy, a birth, or that an employee is breastfeeding, there's an obligation to prevent exposure to any significant risk. And the employer must give information to that employee about the risk and what action has been taken. I said at the current time, that information really should include the employer's COVID secure policy. And then, unless the risk can be avoided through other action, the employer will need to temporarily alter the woman's working conditions, so long as that's reasonable and it would avert the risk. That could include changing working hours, allowing increased work from home. If it's not reasonable to take those steps to alter the working conditions, or if the risk can't be avoided, the employer needs to offer the woman suitable alternative work.
And what would suitable alternative work be, and what if there wasn't any available?
Well, an offer of alternative work would need to be suitable for the employee and appropriate in the circumstances. And the terms and conditions that apply to it can't be substantially less favourable than the employee's current terms and conditions. If there's no suitable alternative work available, or if the employee refuses it, the employer will need to think about suspending the employee for as long as is needed to avoid the risk. And that will need to be on full pay unless the employee has unreasonably refused suitable alternative work. I'll note that during the pandemic, many employers have placed pregnant women onto furlough to avoid exposing them to the risk of COVID, but that scheme has ended now. So the previous steps that I've just described will apply. COVID can be a particularly tricky subject around pregnancy, especially without the option to furlough, because many pregnant women, I think quite understandably, have been unsure and concerned about both the potential effects of the virus and the potential effects of the vaccine. So while no two workplaces or situations are the same, we can't, offer blanket solutions to it, we generally say, be open to thinking creatively, also be clear about what the business needs, document your risk assessments and your decisions, and, as all things with this topic, be sure that you're consistent and genuine. And then finally, to be complete on this, I also, oh no, I think I have a cat audience. Sorry about that. To be complete, I ought to note that the first 2 weeks of maternity leave that starts with the day on which birth occurs are also a health and safety measure. That period's 4 weeks for factory workers. That's called compulsory maternity leave, and it's actually a criminal offence to allow your employee to work during that time.
So when we hear of these cases where superwomen are back at work within days, like it's a badge of honour, their employers are actually committing a criminal offence.
Afraid so.
Now, sadly, there are some occasions where women experience pregnancy loss, and even the best meaning employers can sometimes be unsure on how best to deal with this situation, or indeed what the rights are. Jen is going to talk about pregnancy loss, and we're mindful that this could be a trigger topic for some viewers. So if you'd rather not listen to this section, please just mute us until I start speaking again. Now, pregnancy loss can cover loss of pregnancy at any point while pregnant and includes miscarriages up to 24 weeks and stillbirths. Jenna, can you talk to us about pregnancy loss and the rights involved there?
Yeah, sure. At the moment, there is quite a drastic difference in the law as to how pregnancy loss is treated. It depends on the timing of the pregnancy loss. If it occurs in the first 24 weeks, that doesn't actually class as childbirth, and therefore there's no right to any maternity leave or pay under the maternity legislation. However, if a pregnancy loss occurs after 24 weeks, the employee's maternity leave will start the day after the birth, if it had not already started. And in the usual way, the employee can return to work at any time before the end of the additional maternity leave after giving 8 weeks notice. But of course, the first 2 weeks after birth are the compulsory period of maternity leave. So it all really comes down to a sort of all or nothing approach. And you can see how differently two employees would be treated if one experienced a pregnancy loss at, say, 23 weeks with no right to time off or maternity pay, and another experienced pregnancy loss at 25 weeks with the right to potentially take up to 52 weeks off work on maternity leave, and with potentially SMP, statutory maternity pay, as well. So some companies, such as John Lewis, have gone out of their way to try and equalise the situation somewhat. They've introduced a 2 weeks paid time off for all pregnancy losses. And it's worth mentioning that there's a similar drastic difference when it comes to the protected period for the purposes of pregnancy and maternity discrimination, which we'll come on to. But it again depends on when the pregnancy loss occurs. If it's in the first 24 weeks, the protected period will only last for an extra 2 weeks after the end of the pregnancy, or if it's after the first 24 weeks, then the protected period would end at a substantially later point. Employers should be aware, in the context of pregnancy loss, that there are different types of miscarriages, and some can even result in cancerous cells, called a molar pregnancy, which is thankfully quite rare, but it can result in the employee needing regular follow-up appointments over a number of months. Pregnancy loss is undoubtedly a deeply sad event, and that is, of course, the case whether pregnancy loss occurs at 6 weeks or 23 weeks. The employee may well need time off to grieve, and to recover both physically and mentally. If the employee does take time off, they can take it off, for example, as sick leave, and employers should mark that down, if they do take it as sick leave, as pregnancy-related leave, and discount it for attendance purposes. One final point, that it's important for employers to be aware of, is that they shouldn't, of course, assume or even act on any assumptions that because an employee has had a miscarriage, that indicates that the employee is going to try again and will become pregnant again soon. So, for example, if a promotion was on the cards, but an employer changed its mind because of the employee's pregnancy loss and its assumptions around this and what might happen, the employer may well face a detriment or discrimination claim in relation to the failure to promote.
Thanks, Jenna, for covering that difficult topic. Let's think now about the next stage, where the employer is trying to work out exactly what they have to pay to the employee and probably what the ultimate cost to them will be as well. So, Jenna, what are the criteria for statutory maternity pay, SMP, to be payable?
Well, there are quite a few criteria. There are 6 in total. First of all, for the employee to be eligible for SMP, they must have been continuously employed for at least 26 weeks by the end of the qualifying week, which is the 15th week before the expected week of childbirth, which we'll call just the EWC. So the point here is, SMP is not a day one right. And so what that means in practice is that if an employee is already several weeks pregnant by the time they start their job, she won't qualify for SMP. But it's important in this context to note that there is no requirement for the employee to still be employed any later than the qualifying week. And we'll elaborate with some examples of this later. The second requirement relates to normal weekly earnings, which mustn't be less than the lower earnings limit for NIC purposes. Currently, the limit there is 120 per week, so it mustn't be lower than that. Thirdly, the pregnant employee has to still be pregnant 11 weeks before the start of the EWC. In other words, she has to reach around 29 weeks or have already given birth by this point, which does include stillbirths after 24 weeks. Fourthly, she must give her employer at least 28 days notice, or if not reasonably practicable, then as much notice as is reasonably practicable of the date that she actually intends the SMP to start. Fifth, she must also have given a certificate, which at this point usually is the MAP B1, confirming the date of the EWC to her employer, either before the birth or no more than 3 weeks afterwards. Or if there is a good cause for the delay, maybe she's been hospitalised, then as soon as reasonably practicable. The final requirement is that the employee must have ceased work. So SMP can't be paid until the employee has actually stopped work. But this also means that SMP entitlement, once triggered by this final requirement of ceasing work, is not dependent on the person remaining an employee. And Alison will be speaking more later about when SMP ceases, as this is a common pitfall. And it's worth noting that the definition of employee for SMP purposes is relatively wide. As an example, it also includes agency workers with some minor exceptions. Those not eligible for SMP, perhaps because they've got an insufficient period of service, may be eligible for maternity allowance instead. So it'd be good practice for an employer to flag that up in case the employee is unaware. In relation to the payment of SMP, I wanted to go back to the case I mentioned earlier, which involved the respondent Corsica Taste of Europe Limited, which involved the deliberate alteration of the claimant's shifts to avoid antenatal appointments. The respondent in this case actually ended up dismissing the pregnant employee 3 weeks before her maternity leave was due to start, supposedly due to performance and behavioural concerns. This was nonsense, said the tribunal, and the real reason was because of her imminent maternity leave and the respondent's concern that they would have to pay her SMP. They thought that the dismissal meant that that would be the end of any payments due to her, which of course is incorrect. The respondent's concern about paying her SMP, which is something that's shared perhaps by many employers, was also misguided, as employers can generally reclaim the majority, if not all, of the cost of SMP. So pregnant employees aren't the sort of burden that some employers think they are.
And how long is SMP payable for, and how much is it? Remind us.
Yep, so just as a quick reminder, it's payable for a period of 39 consecutive weeks, and that period is split into two. First of all, we've got the first 6 weeks where it's payable at 90% of the employee's normal weekly earnings, and then SMP during the remaining 33 weeks is payable at the current rate of £151.97, or the 90% rate that I just mentioned, whichever is lower. Of course, if the employee does take the full 52 weeks of maternity leave, then the last 13 weeks would end up being unpaid, unless, of course, there's some kind of enhanced scheme there. So some employers do offer enhanced contractual maternity pay, but sometimes that has to be repaid if, for example, the employee doesn't return to work for a certain period after her maternity leave has ended.
Yeah, and I've seen the calculation method produce interesting results in different cases. For example, an employee who'd received her substantial bonus in the calculation period ended up receiving a really high amount for her first 6 weeks, more than her normal salary even, which worked out really well. Then also you sort of mentioned that a lot of employers do choose to pay enhanced maternity pay, probably increasingly to sort of encourage retention of these women in the workplace. And we often find ourselves at Thomas Mansfield sort of having conversations with our clients and with our HR teams that we work with around what's the norm, what's the market doing, what are our competitors doing, what's best practice, where do you see this going? And these discussions are often not just about maternity pay, but at the moment in particular, should we equalise it with our shared parental leave, with our paternity leave? These sorts of discussions, which are really interesting, and we also can sort of look at what you might be able to do as employers to try to encourage a return of these people to the workplace, things like, as Jenna just mentioned, repayment clauses and that sort of thing. So we'd be really happy, and I've just published an offer in the offer button that you hopefully can see on your screens. We'd be really happy to have one of these conversations with any of you, completely complimentary, no obligation, but just to have a discussion around what you're doing, what you're thinking of doing, where you'd like to sort of take it in terms of the future of maternity and paternity policies. So if you would be interested in having one of those discussions with one of us, please do either click the button for the offer now and just register your interest, and we'll be in touch with one of us to have one of these conversations with you. Alternatively, you can just write the word conversation in the chat box if that's easier, and then we can pick it up from there, and we'll get in touch, because it's really good to know what everyone's doing and what everyone's thinking, and how we can move this forward so that eventually, hopefully, there'll be more like true equality in the workplace. So moving on now to the point where the employee's gone on maternity leave. Alison, can you talk us through the employee's rights during ordinary and additional maternity leave? First of all, who's entitled to take maternity leave?
Yeah, so the first thing to say is that unlike with SMP, there's no service requirement for leave. It's a day one right. To qualify for maternity leave, an employee must notify her employer that she's pregnant, the EWC, the expected week of childbirth, and the date on which she intends her maternity leave to start. And that mustn't be earlier than the 11th week before the EWC. The employee needs to do that before the end of the 15th week before the EWC, so you can see there's about a 4-week gap there, and there's no need for that to be in writing, but ideally it should be. A quick explanation of some terms before we go on. When a child is born alive at any stage of the pregnancy, or when a child is stillborn after 24 weeks, the mother is entitled to take 52 weeks of maternity leave, and the first 26 weeks are known as ordinary maternity leave, which we'll now start calling OML, and the second 26 weeks as additional maternity leave, or AML.
And what happens to the employee's rights to, for example, pay and pension contributions during maternity leave?
So broadly speaking, and the devil is in the detail, during statutory maternity leave, an employee has a legal right to benefit from the terms and conditions that would have applied if she'd been at work, aside from the terms around her remuneration. If an employee's terms and conditions are changed, or if she's otherwise subject to a detriment because of her leave, that might be maternity discrimination, and we'll come on to detriments and discrimination in more detail later. But broadly, that means that benefits need to continue during maternity leave, including holiday accrual, health insurance, anything like a gym membership, anything that isn't strictly for use while doing business. And then bonuses are a complex area. The position there depends on the purpose of the bonus and the terms of the employer's contract. But as a general principle, a bonus that is considered part of salary won't necessarily be payable because remuneration can be changed during maternity leave, but a bonus that's considered a benefit will continue to be payable, although it might be able to be paid pro rata to reflect the time a woman's been absent. And on pension contributions, they need to be paid in full by the employer, so long as the employee is receiving any pay at all. They can't be reduced because the employee's pay is reduced. And in most schemes, the employee's contributions might be reduced based on what she's actually being paid. And of course, important to remember, the employee's own contractual obligations also continue during the leave. So she needs to abide by, for example, her duties around confidential information. And she could also be disciplined if that becomes relevant. Otherwise, I would really always advise employers to tread really carefully on that and seek legal advice.
And any other points, sort of more general points to note about the maternity leave period?
Well, firstly, one thing that won't apply while on maternity leave is the right to sick pay. That's counted as remuneration. And then I should probably just cover off a couple of quick points about keeping in touch during maternity leave. So an employee can work for her employer during maternity leave for up to 10 days without the leave being brought to an end. And lots of employers and employees, like to use those days so the employee can stay in touch with the workplace, do things like attend training to keep her skills relevant. They're often referred to as keeping in touch days or KIT days. Most employers pay for these days at full normal pay rate, although that's just a matter of agreement. Some employers might offer time off in lieu instead, as for example. An employer also may and really should, which we'll come on to again later, I think, keep in reasonable contact during maternity leave. That's a different thing to the KIT days I've just covered. And what that means is an employer can make contact to discuss, for example, return to work arrangements, promotion opportunities. I'll touch on that a bit again when we start talking about redundancy.
Yeah, I do find there's sometimes a fear of getting in touch with someone who's on maternity leave, but this really needn't be the case. And I would say to all employers that it's good practice to chat with your employee before they actually go on leave and ask, would they like to put in the diary a monthly or quarterly catch up just so that they know what's going on at work. Any developments, that sort of thing, or do they want newsletters sent to their personal email, or would they rather not? If you have that conversation before they go on leave, it can be much easier to sort of pick up the phone, if something crops up that you think, oh, they probably should be aware of this. So I'd really encourage employers to have that sort of conversation. We have got a question come in, which I may sort of park and come back to, but just to say that we have got it. It's around health and safety for pregnancy and COVID, and whether the requirement to medically suspend after 26 weeks of pregnancy, if alternative work like home working can't be accommodated, is that regulation still in place? I'm not 100% sure if you're talking about the situation where you can, if someone is unwell after a certain point in their pregnancy, you can sort of require them to start their maternity leave, or if you're talking about something that is literally just specific to COVID. And my initial reaction is I probably want to double check the regs, because I was looking at some yesterday and it's actually incredible how many permutations of for example, the furlough scheme there were. It's mind-boggling. So I may check that and come back to you if that's okay. Alison, so when the employee is ready to return to work, or her period of leave is about to come to an end, what happens then? What should employers be thinking about?
Yeah, well, after that initial compulsory 2 or 4 weeks, for health and safety reasons, it's up to the employee when she wants to return to work. The assumed date for legal purposes is at the end of her AML. So if that's when an employee wants to return, she doesn't really need to notify the employer at all. But if an employee wants to return earlier, she should give 8 weeks notice of her return date, although she can return on less notice or even on no notice if the employer is happy for her to. But the employee can only delay the return to work date if the employee wants to return early and hasn't given the sufficient notice. She absolutely must be allowed to return at the end of her AML, if not sooner.
And does the employee automatically come back to her old role?
Well, if she's only taken that initial 26 weeks of OML or less, she will be entitled to return to the same job in which she was employed before her absence. And her terms of employment there must be the same as, or no less favourable than they would have been if she hadn't been away at all. And yes, there's a redundancy situation, which we'll address later. And the employee is also entitled to benefit from any improvements that would have applied while she's been away, such as an across-the-board pay rise. During and after AML, the situation is a little bit different. Generally, an employee is entitled to return to the same jobs and the same terms and conditions, but the employer does have more flexibility, and if there's a reason other than redundancy where that isn't reasonably practicable, the employee might be asked to return to a different job that's both suitable for her and appropriate in the circumstances. The terms and conditions there must not be less favourable than they would have been if she hadn't been absent.
And what are the risks for employers if that isn't followed?
So if an employee isn't permitted to return to the same job on no less favourable terms and conditions, or if the employer doesn't offer the employee suitable alternative employment, the employer will be at risk of a claim of pregnancy and maternity discrimination and automatically unfair dismissal if there's a dismissal, or unlawful detriment if there isn't. If the employee returns from AML and is offered suitable alternative employment but unreasonably refuses it, then it won't be automatically unfair to dismiss her. But if the offer actually isn't suitable, then the employee might refuse to accept it and treat herself as constructively dismissed, and then bring a claim of unfair dismissal. Even if she does just go ahead and accept the unsuitable offer, she might bring a complaint of unlawful detriment or of sex discrimination if the change in job or terms was because of her pregnancy or maternity leave. So I'd really urge employers to be extremely cautious of the risks on this point. It's a really complex area of law. As I think we've highlighted, compensation claims can be really considerable.
Thanks. And I guess this is slightly one of the tricky areas as well, but can you talk about the notion that some employers have that an employee on maternity leave can't be made redundant? I mean, is it the case that employees on maternity leave can't be made redundant?
So actually, not at the moment, although I'll come on to that. It can seem complex and risky for employers to make an employee who's pregnant on maternity leave redundant. And there's been a lot of press around the issue. A lot of that is caused by situations where redundancy wasn't really a genuine redundancy, but was actually a discriminatory excuse for pushing someone out, or retaliation for their leave. And so the employer responsible was quite reasonably criticised and was liable for substantial compensation to the employee. So I can see why the myth that it's just not allowed is a common one. But the truth is that an employee can be made redundant during pregnancy or maternity or parental leave, provided it's a genuine redundancy situation and the employee's selection is not because of their pregnancy or their leave. You can't shortcut those points. A fair process also must always be followed, and that must include carrying out the exact same consultation process you'd go through with any other employee placed at risk. That's one reason, as we've touched on, it's really important to agree how you'll keep in touch with an employee who's going on maternity leave. However, employees do have additional rights if a redundancy situation arises during their maternity leave. If it's not practicable by reason of redundancy for the employee to continue under her existing contract, the employee is entitled to be offered a suitable alternative vacancy where there's one available, and that should start immediately after her existing contract ends. A job will be considered a suitable alternative where the work is both suitable and appropriate for the employee in the circumstances, and the role and the place of work and the other terms and conditions are no less favourable to her than if she continued in her old job. And that gives the employee on maternity leave priority over other employees who are at risk of redundancy. It's a rare example of lawful positive discrimination. If the employer doesn't follow this requirement, the employee is likely to have grounds for claims for automatically unfair dismissal, sex discrimination, and potentially pregnancy and maternity discrimination.
So to be clear, it isn't the case that where an employer has, say, 3 people doing the same job and wants to reduce that headcount to 1, they have to give the 1 role to the lady on maternity leave. But if they have another vacancy, let's say in a different department, that would be suitable for the 2 people being made redundant, they must give it to the employee on maternity leave.
Yes.
So, and having given us such a great explanation of what the current position is, I'm now going to ask you to address the fact that it looks fairly likely this is going to change at some point in the future, doesn't it?
Yes. So after research by the Equality and Human Rights Commission in 2016 found that 11% of women reported having been dismissed or forced out of the workplace, around a pregnancy or maternity situation, the government launched a consultation on improving the legal protections for women who are pregnant or on maternity leave. And following that, in 2019, the government announced that it would extend redundancy protections. So the proposed change would extend the priority we've just discussed for suitable alternative vacancies and redundancy situations, so that it starts earlier, once the employee has notified the employer about her pregnancy, and it would end much later, 6 months after the date of a woman's return to work, as well as covering those taking adoption or shared parental leave. It's apparently due now for inclusion in broader new law and employment protections, and the government reaffirmed their commitment to that in April, but there's currently no timescale for its full introduction. And there have also now been 2 unsuccessful attempts to pass the Pregnancy and Maternity Redundancy Protection Bill as a private member's bill. That bill would go further than the government's proposal to prohibit employers from making employees redundant during pregnancy, during maternity leave, and for 6 months after the end of maternity leave, except where the employer ceases to carry on business.
Okay, so watch this space. Jenna, can you now talk a bit about flexible working applications, as there tends to be, they're very common after a period of maternity leave?
Yeah, sure. So First of all, flexible working, just to say, it can be requested by any employee with 26 weeks service. So in the case of a mother looking to return to work, she's likely to have that service. To class as a statutory request, the employee's application must meet several criteria, including it must state that it is a statutory request. Employers have got 3 months to give a decision, including time for the appeal, if they allow that, or it's best practice to allow for an appeal. Although that 3-month period can be extended if both parties agree. So, for example, if the employer wants to agree to a trial period, then the 3-month period can be extended to allow for that. There is a duty on employers to consider requests in a reasonable manner. What that actually means is elaborated on by ACAS in its statutory code of practice and its guidance on flexible working requests. Employers can only rely on the 8 statutory grounds if they wish to reject a request, which include, for example, an inability to reorganise work among existing staff. There's a recent case from earlier this year in which an employee was awarded a surprisingly high level of compensation. This is a case of Mrs. Thompson and Scancrown trading as Manners. The employer here was an independent estate agent. And what happened was Mrs. Thompson submitted a flexible working request while she was on maternity leave, in which she asked to do 4 days a week instead of 5, and she wanted to change her finish time to 6 o'clock instead of 5 o'clock, because the nursery was about an hour away and it closed at 6. But her request was declined by her employer and she ended up resigning. One of the tribunal claims that she brought was for indirect sex discrimination. Now, although the tribunal did take the legitimate aim to be the importance of consistency and continuity in client relationships for successful sales in the estate agents with their clients, the respondent lost because its refusal was not proportionate to the real need of the business to maintain successful relations with customers. So she did end up winning her claim for indirect sex discrimination, and for that claim alone, she was awarded almost £185,000, which is just incredible. But it just goes to show that employers shouldn't forget to consider the potential discriminatory impact of rejecting flexible working requests, even if they aren't made under the statutory scheme, for example, because of insufficient service. Obviously, the case I've just mentioned was based on childcare responsibilities, but rejections could also amount to, for example, disability discrimination. So it could be a failure to make a reasonable adjustment by refusing a request.
Thanks, Jenna. And I think it's a really good warning because it's so often very easy to sort of meet the criteria to reject under the statutory scheme, but you need to think about the wider potential claims as well. Moving on now, I'm not sure how many employers have dealt with employees who are either breastfeeding their baby or expressing milk. But Jenna, could you just give some pointers for employers to consider on this area?
Yeah, it'd be interesting if people could put in the chat box actually as to whether they've come across the issue of breastfeeding in the workplace, just to get a feel for whether it is really rare or not. But yeah, in terms of breastfeeding, employers are required to comply with various health and safety rules, such as the requirement to provide suitable facilities for breastfeeding mothers to rest, including facilities to lie down, and to provide adequate rest and meal breaks. It's worth pointing out that toilets do not class as suitable facilities for these purposes. Alison has already mentioned that the requirement to carry out a risk assessment also applies to employees who are breastfeeding. And one final point to note is that although there isn't technically any statutory right for workers to take time off to breastfeed, employers should try to accommodate women who wish to do so to lessen the risk of a possible discrimination claim.
Thanks, Jenna. So, Alison, what we're seeing is that there are lots of different ways that employees who are pregnant or on maternity leave can gain protection. And are there also any sort of overarching general duties on employers?
Yeah, so a lot of what ties together what we're going through with you today is that pregnancy and maternity is one of the protected characteristics under the 2010 Equality Act. An employer must not treat the employee unfavorably because of a pregnancy, because of any illness suffered as a result of it, or because of maternity leave during what's known as the protected period. That begins when a woman becomes pregnant. When it ends, depends on whether she has the right to OML and AML. If she doesn't have that right, like a worker or a woman who experiences a miscarriage before 24 weeks, the protected period will end 2 weeks after the end of the pregnancy. If she does, the protected period will end at the end of AML or when she returns to work if that's earlier. So examples of unfavourable treatment, and that's a lower threshold than in normal discrimination claims, other types of discrimination claims, includes things like dismissal due to informing the employer of a pregnancy, selection for redundancy because of something to do with the pregnancy, refusing to provide training or promotion, reduction of pay or hours, or pressure to resign. And discriminatory decisions that are made in the protected period but which take effect afterwards could also be brought as pregnancy and maternity claims. There are also various protections from detriment, such as for reasons connected to pregnancy or statutory maternity leave. And if an employer dismisses an employee or selects her for redundancy when the reason or the principal reason for that decision is connected to her pregnancy or the fact that she took maternity leave, that would be an automatically unfair dismissal. Don't forget too that employers mustn't victimize a job applicant or an employee because they are or because they intend to become pregnant, or because they make a pregnancy and maternity discrimination complaint.
Thanks, Alison. Now, you've listened to us talk for a while, so I'm going to do the most complicated poll in the world. It does take some thinking about, but it's quite a good one. So we're asking in this poll, in which of these circumstances would an employee lose their right to SMP? So then you've got 5 examples. If the employee is dismissed for misconduct 2 weeks before her expected week of childbirth, if the employee is made redundant during her maternity leave, if the employee resigns whilst on maternity leave, if the employee starts working for a new employer during her maternity leave, or if the employee returns to work before the end of the SMP period. So the poll is, would the employee lose their right in all of the above situations, none of the above situations, only in situations 1, 4 and 5, or only in situations 2, 3 and 4, or only in situations 4 and 5. So I'm going to leave it there for a minute and be quiet for a moment so that you can actually work through. And then I'm going to ask Alison to reveal the correct answer in a moment. We've got a couple of answers coming in. Split decision at the moment. Well, this one really has stumped everyone, I think. Okay, another answer coming in.
Oh, this is good. It's controversial.
Oh, we're getting answer 4 coming in now as well. Okay, so it looks as though I won't end it just yet, but it looks as though at the moment 50% of people think 4 and 5. 25% of people also think that if an employee is dismissed, for example, for gross misconduct or something, just before she goes on leave, she could also lose her right to SMP. A couple of people, or 18%, think none of the above situations. I'm going to end the poll there and ask Alison, can you reveal the correct answer?
That was exciting. So the correct answer is E, the last one. So just about most people got this one right. The employee would lose their right to the SMP only in the last 2 situations, 4 and 5. So that's if they start working for a new employer during the maternity leave, or if they return to work before the end of the SMP entitlement period. So let me quickly explain why. So once an employee is qualified for statutory maternity pay, and Jen has explained the criteria on that, they are eligible to be paid for the remainder of the SMP entitlement, even if they're made redundant before or during the maternity leave period, or even if they're dismissed or resign during that time. There's no requirement for the employee even to intend to return to work to be eligible for SMP, although lots of contractual maternity pay schemes will have a sort of clawback provision where an employee chooses not to return. But if an employee works for a new employer after the child is born, her SMP entitlement ceases. That's the case whether or not they remain an employee of the original employer. And of course, once an employee returns to work with the original employer, SMP also comes to an end.
Okay, thank you. Now, before just moving on to the sort of tricky areas, I'll just go to one of the questions that's come in, which is, will there be new rules, more rights for the pregnant woman when they're employed in the current company for less than 2 years in a redundancy situation? And I expect you're talking about the sort of consultation that's ongoing at the moment. I don't believe that they are proposing to introduce a sort of a new unfair dismissal right for pregnant employees with less than 2 years service. But the way that they may achieve a similar effect is that if the employee in question returns from maternity leave and she still has less than 2 years, she's protected from redundancy during that period. So obviously it's a consultation at the moment. There are no definites around it, and the sort of detail of it hasn't been agreed even. But to an extent, it would circumvent that 2-year rule, certainly on how the consultation looks. Alison, is that your understanding of it as well? You're muted.
Yes, of course, there were rights through the sort of, the unfair dismissal route, which generally applies from 2 years, although there are exceptions, and there are also rights through the sort of the discrimination route. And I think sort of what's being focused on here is the sort of the increased protections through the straightforward, whether they're not straightforward, pregnancy and maternity leave protections. I hope that makes sense. Really glad to follow up with anyone for whom it doesn't quite.
Yeah, and of course, if the pregnancy is somehow the reason for the redundancy or the dismissal, then it would potentially be automatically unfair, which doesn't have a qualifying period. So yeah, but I'm assuming that you're talking about, if there's a mass scale redundancy, that sort of thing. One of the tricky areas, if we sort of move on to that, one of the tricky areas that I sometimes see is disciplinaries, where in a similar way to redundancies, employers can be hesitant to deal with a disciplinary issue that perhaps comes to light during an employee's absence on maternity leave. And employers are unsure what to do with this. Now, I would say, obviously, you take it on a case-by-case basis, but it isn't, it's not unheard of that when someone is on an extended period of leave and someone else has to pick up their work, etc., something gets uncovered that shows you either there's been misconduct or some serious incapability. And I've certainly dealt with cases where extremely serious misconduct has been uncovered once someone's gone on leave. And in those circumstances, you don't have to wait until the person returns from maternity leave. If you uncover it a couple of weeks before they return, it's less of a problem. But if it's right at the start, there may be all sorts of reasons why the employer simply can't ignore this and needs to get it resolved. So, always take advice, but don't think that you absolutely can't, do anything with a disciplinary just because someone's on a period of maternity leave, because you absolutely can, and you're entitled to get to the bottom of whatever it is you've uncovered. Another tricky situation that I'll ask you to talk to us about, Jenna, is in practice it does, it's not that uncommon where you might have two people carrying out the same job. One of them's about to go on maternity leave, but at the same time the company is deciding that it actually only needs one person doing that job going forward. And obviously the person who's about to go on maternity leave is one of the two being looked at. What issues might arise here for the employer, Jenna?
Yeah, so as the law stands, the employer in that situation that you've just described, Angie, would be perfectly legally entitled to carry out a fair redundancy process. And if the pregnant woman scores the lowest, then the employer can make her redundant, even if she might be about to go on maternity leave. Obviously, the redundancy has to be genuine, etc. But yeah, it's legally perfectly possible. There's no obligation on an employer to give priority to a pregnant person before she starts her maternity leave in a redundancy situation. So the thing is that in practice, if an employer is about to make a pregnant person redundant just before her maternity leave is about to start, I'd imagine she's likely to want to challenge that decision. And given that the employee in that situation would be within the protected period for pregnancy and maternity purposes, then obviously there's a danger she'll be wanting to bring that type of claim. And as we've seen from earlier, that type of claim has got the lower threshold of only unfavourable rather than less favourable treatment. In addition, she may have a claim for automatically unfair dismissal if she can show that the reason or principal reason for the dismissal or selection for redundancy is connected to her pregnancy or statutory maternity leave. So the other situation is where in that scenario that the pregnant woman actually scores the highest and she's kept on. But in that case, given that she's about to go off on maternity leave, the employer is then going to need to arrange cover. And given that the other person is being made redundant, it's unlikely that they would want to stay on and do any favours for their employer. In practice, in this situation, the employer may wish to just try and consider, if possible, postponing the idea of a redundancy process until after the pregnant employee has returned from maternity leave.
Thanks, Jenna. I guess that may change if the law does change, as we anticipate at some point, and the potential for employers to sort of wait and see how the workload is down the line might be riskier for employers if they then have an absolute prohibition on sort of making redundancies to someone who's just returned from mat leave. So that may change going forwards, but you can definitely see how a pregnant employee would challenge being made redundant in this scenario on the basis that their employer must be thinking, if they choose the pregnant employee for the one remaining role and in a month's time they go on leave for a year, how are they going to cope having no one in the role, or have to get temporary cover in who may not be as good, and how can the fact that their employee is about to be absent for a year not somehow factor in their thoughts? It is a really tricky area to get right. Jenna, what about the where an employer perhaps has picked up on signs of pregnancy, but the employee hasn't actually notified the employer? So for example, the weekly drinks trolley, someone always participates but suddenly stops drinking from it and perhaps puts on a bit of weight. What if she's then either dismissed or selected for redundancy? Could this amount to discrimination even though the employer hasn't officially been told?
Yeah, so in theory, an employer who is unaware of a pregnancy, so who hasn't been told about the pregnancy yet, should be able to defend itself, because the tribunal has to look at the reason why the treatment has happened in a pregnancy discrimination case. However, in the case of really easy car credit and Thompson, which involved the decision to dismiss an employee before they were told about her pregnancy, the Employment Appeals Tribunal appeared to implicitly accept that if an employer treats an employee unfavourably because it believes that the employee is pregnant rather than knows, that could potentially be enough to make the employer potentially liable for pregnancy discrimination. So in practice, whenever an employer makes a decision to dismiss an employee, it's really important to put that into writing for evidence purposes. Because if the employee subsequently notifies the employer about the pregnancy, then as long as the decision was made beforehand, when the employer was oblivious, then even if the decision is communicated after they find out about the pregnancy, then the employer would be likely to successfully defend a pregnancy discrimination claim.
Thanks, Jenna. We're at an hour now, so I'm conscious that you probably all need to get on to whatever else you've got in your day. Thank you, Alison and Jenna. We didn't have that many questions. If we haven't managed to answer any, we'll follow up with you separately. It's probably the best way so that everyone can get on with their day. If you want to get in touch, as I said, if you want to have a conversation, please do be in touch, and we'll sort of have a strategic type conversation about good practice in this area. Our next webinar takes place on Thursday, 25th of November. It's likely to be a popular one because it's the annual review, a look at notable cases, legal developments, and basically anything that HR practitioners should know about. Please go on our website to register, and we hope to see you at that next webinar. So we'll say bye for now.
Bye. Thank you.